Something just happened inside that Manhattan courtroom that nobody in Trump's inner circle was prepared for. Michael Cohen walked to that witness stand, and when he opened his mouth, everything changed. Not in the way legal analysts predicted, not in the way cable news had been teasing for weeks, but in the specific, surgical, irreversible way that happens when a man who knows every secret, who kept every secret, who built his entire identity around keeping those secrets, decides that the time for silence is over. Michael Cohen didn't just testify, he detonated. And what he detonated wasn't a theory, it wasn't speculation, it wasn't the kind of circumstantial evidence that a skilled defense attorney can reframe, recontextualize, and ultimately neutralize in front of a jury. What Michael Cohen delivered to that courtroom was something far more dangerous for Donald Trump. He delivered memory, specific memory, conversations, instructions. A direct line from the decision to pay Stormy Daniels $130,000 to the man sitting at the defense table who Cohen says personally approved every dollar and personally ordered the cover-up that followed. That is the testimony that changes this trial. That is the testimony that the defense cannot simply argue away. And that is what matters. And that is what we are going to break down for you today. Because the implications of what happened in that courtroom extend far beyond a single legal proceeding. They reach into the 2024 presidential campaign. They reach into the question of what the rule of law actually means in the United States of America right now. And they raise a question that this country has never had to answer before in its history. What happens when the man standing trial for felony charges is simultaneously running for the most powerful office on the planet? Let's start with what Cohen actually said. Because the details matter enormously here, and the mainstream coverage has a tendency to flatten them into headlines that don't capture the full weight of the testimony. Cohen's central claim is not complicated. It is, in fact, almost brutally simple. He says Donald Trump knew about the payment to Stormy Daniels. He says Donald Trump approved it. And he says Donald Trump personally instructed him to disguise the reimbursement, the money Cohen was paid back for fronting the hush payment, as legal expenses in the business records. That last part is the heart of the criminal charge. Because falsifying business records in New York becomes a felony, not a misdemeanor, when the falsification is done with the intent to commit or conceal another crime. And the prosecution's argument is that the other crime being concealed was a violation of federal campaign finance law, specifically that the payment to Daniels was an illegal, undisclosed contribution to Trump's 2016 presidential campaign made in the final weeks before the election to suppress a story that the campaign believed could be damaging. Cohen's testimony provides the prosecution with something it could not get anywhere else: intent. Direct, spoken, unambiguous intent coming from Trump himself. According to Cohen, Trump did not stumble into a situation where his lawyer made an independent decision that happened to benefit him. According to Cohen, Trump was in the room, metaphorically and sometimes literally, for every major decision in this sequence. He was told about the Daniels situation. He understood the risk. He authorized the payment. He directed the concealment. He signed the reimbursement checks. Every single one of those claims, if believed by the jury, is a piece of the prosecution's case snapping into place. Now let's talk about what this does to the defense. Because the defense team for Donald Trump did not enter this trial without a strategy. They had a plan, and Michael Cohen's testimony is systematically dismantling that plan in real time. The defense strategy rested on a specific argument about Cohen himself. The plan was to establish Cohen as what legal professionals sometimes call a rogue actor, someone who acted independently, outside the knowledge and authorization of his client, making decisions that served his own interests, and then retroactively attributed those decisions to Trump. This is not an unreasonable argument to attempt. Cohen, after all, has a documented history of dishonesty. He pleaded guilty to lying to Congress. He has admitted under oath that he is a convicted felon whose relationship with the truth has been inconsistent at critical moments. He has written nakedly hostile books about Trump and made media appearances that careful legal witnesses avoid. He is, by any objective measure, a complicated witness. But here is the problem the defense faces. Complexity is not the same as falsity. A witness can be complicated, can have mixed motives, can have a history of dishonesty in other contexts, and can still be telling the truth about the specific events at the center of this trial. And more critically for the defense's purposes, Cohen's account of these events does not exist in isolation. It is corroborated. Documents corroborate it. Other witnesses corroborate pieces of it. The checks themselves, physical checks bearing Trump's signature, reimbursing Cohen in installments, corroborate the financial mechanics of exactly what Cohen described. You cannot cross-examine a check. You cannot put a canceled payment document on the stand and discredit it by pointing out that it lied to Congress. The paper record exists. The question is what it means. And Cohen's testimony provides the meaning. So the defense must now accomplish something very specific and very difficult. They must convince 12 jurors that Cohen is not just an unreliable narrator. They must convince those jurors that Cohen fabricated the specific conversations he described, the specific instructions he says he received, the specific words Trump allegedly used when directing the cover-up. Not that Cohen is generally untrustworthy, not that Cohen has reasons to lie, but that Cohen is lying about these specific things right now in this courtroom under oath in a way that is specifically contradicted by the physical and documentary evidence that surrounds his account. That is an extremely high bar, and whether the defense team can clear it is the central dramatic question of this trial's remaining days. Let's be direct about the political dimension. Because pretending this trial exists in a vacuum, that it is purely a legal proceeding with no connection to what is happening simultaneously in the American political system, would be a kind of willful blindness that serves no one who is genuinely trying to understand this moment. Donald Trump is not just a criminal defendant. He is the presumptive Republican nominee for the presidency of the United States. He is running against the sitting president. He holds rallies where tens of thousands of supporters gather. He raises money at extraordinary rates, including a documented surge in small-dollar donations that appears to accelerate every time a court date approaches. He has constructed an entire political identity around the narrative that the legal proceedings against him are not a pursuit of justice, but a weaponization of the justice system by political enemies who cannot defeat him at the ballot box. That narrative has been effective. Remarkably, stubbornly, confoundingly effective, despite 4 separate criminal indictments across different jurisdictions, despite civil judgments finding him liable for fraud and for sexual abuse, despite the weight of documented evidence accumulated across years of legal proceedings. A significant portion of the American electorate has internalized the story that all of it, every charge, every verdict, every ruling, is politically motivated persecution. And that portion of the electorate is not small. This is what makes the Cohen testimony so significant beyond its legal implications. It forces the question that the persecution narrative has successfully avoided. If Trump personally approved the payment, personally ordered the concealment, personally directed the falsification of records, if the man at the center of the alleged criminal scheme is not some rogue subordinate but the principal himself, then the persecution narrative requires believing that the entire mechanism of New York State criminal law was orchestrated to prosecute a man for crimes he demonstrably committed, as attested by his own closest associate, corroborated by documentary evidence, and witnessed by multiple individuals with direct knowledge. At some point, the accumulation of evidence becomes its own argument, and Cohen's testimony represents a significant addition to that accumulation. The constitutional dimensions of this moment deserve their own clear-eyed examination. It is true, and the record should reflect it clearly, that a criminal conviction in the United States does not legally disqualify a person from running for president. Article 2 of the Constitution establishes the eligibility requirements. Natural-born citizen, minimum age of 35, 14 years of residency, and a criminal record is not among them. The Supreme Court, in earlier proceedings related to Trump, has reinforced the principle that states cannot unilaterally add disqualification mechanisms that the Constitution does not specify, so a conviction, if it comes, does not remove Trump from the ballot. The voters decide. But the voters deciding in a context where the Republican nominee has been found guilty of felony charges by a jury of his peers in a court of law, following a trial where his own former attorney testified that he personally directed a criminal conspiracy, is a context with no historical precedent in American democracy. The practical consequences cascade in ways that are genuinely difficult to project. Independent voters, who in close elections often determine outcomes, respond to criminal convictions differently than partisan-based voters do. Moderate Republicans who have held their support despite discomfort may find a guilty verdict to be a different kind of threshold than an indictment. Campaign logistics become genuinely complicated if sentencing includes conditions on movement and activity. None of this is resolved, all of it is in motion, and Michael Cohen, sitting in that witness chair in Manhattan, speaking about conversations that happened years ago in the offices and cars and phone calls of Trump's world, put all of it further into motion with every word he delivered. There is a phrase that legal analysts use when a piece of testimony achieves a particular kind of narrative completeness. They call it the missing link, the element that transforms a circumstantial case into a direct one, the piece that makes the picture whole. Cohen's testimony about Trump's explicit instructions to falsify the business records is that missing link. It is the piece the prosecution needed to connect every other element of the case to the man at its center, whether the jury believes it, whether 12 people from Manhattan, having heard Cohen's full testimony and faced the full force of the defense's cross-examination, decide that this complicated, convicted, hostile witness is telling the truth about these specific events, is the question that will define the next chapter of this story. But the testimony has been given. It is in the record, and whatever verdict emerges from that jury room will arrive in a country that already heard Michael Cohen say, under oath, with his name attached and his liberty potentially at stake for perjury if he lied, Trump approved the payments, Trump ordered the concealment, Trump signed the checks, the courtroom heard it, the country heard it, and history is now recording every single word. What happens next is in the hands of 12 jurors and the American people.